The House has resumed. Mr. Chairman.
Mr. Speaker, the committee has considered the Summary Proceedings Bill No. 2 and reports it without amendment. Mr. Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion will say aye. Contrary, no. The ayes have it. Well, I have to deal with the bill, which is this bill is set down for third reading forthwith, and a member is seeking a point of order. Honourable Darren Hughes.
Mr. Speaker. Mr. Speaker, I have made a mistake, and I seek leave to correct that mistake because I should have cast a lower number than what I did for the Labour Party. So I seek leave to correct the vote.
Leave is sought to correct the vote. Is there not opposed to that course of action? There appears not.
It should have been 30 Labour votes in favour of the first and second reading, and during the committee stage I incorrectly cast a higher number, and for that I offer a fulsome apology this hour.
The apology is accepted and the record will be corrected. We move now to the third reading.
Speaker.
Honourable Kate Wilkinson.
Thank you, Mr. Speaker. I move that the Summary Proceedings Amendment Bill No. 2 be now read a third time. As the House has heard, this bill addresses a misclassification of some minor property offences by adding them to Schedule 1 of the Summary Proceedings Act 1957. It also validates the proceedings that have occurred without jurisdiction because of the misclassification. The misclassification was identified in a recent District Court case. An amendment to the Summary Proceedings Act 1957 that came into force in June 2008 had intended to make some minor property offences purely summary offences that are heard by a judge alone. The 2008 amendments aimed to do this by excluding them from Schedule 1 of the Summary Proceedings Act. In fact, this had the opposite effect, making them purely indictable offences that should be tried before a jury. This misclassification should be rectified as quickly as possible to minimise its impact on our court system. It is not desirable to leave it to be dealt with by the courts as a matter of statutory interpretation. Leaving the question to be resolved by way of appeals would be a lengthy and costly process that would create uncertainty for the other 46,000 cases. Further, if it was ultimately found that these cases should be tried before a jury, the costs associated with holding jury hearings for these minor offences would be a significant strain on our court's limited resources. This technical error does not undermine the fairness or the appropriateness of any convictions. It is appropriate that low-level offences of this nature be dealt with summarily. There are two steps, Mr. Speaker, involved in rectifying this issue. Firstly, this bill will stop any more proceedings occurring without jurisdiction by adding the relevant sections of the Crimes Act to Schedule 1 of the Summary Proceedings Act. Secondly, this bill will validate any proceedings that have already occurred. In the longer term, the proposed Criminal Procedure Reform and Modernisation Bill will abolish the terms summary and indictable, along with the overly complex system of offence classification. The Summary Proceedings Act 1957 will largely be replaced to make court processes clearer and more efficient, improving access to justice for court users and promoting public confidence in the system. This bill is due to be introduced before the end of the year. I close, Mr. Speaker, by acknowledging the cooperation we have had from members of the House in dealing with this matter expeditiously, and I can commend this bill to the House.
Question